can you please tell us something about the Employees Compensation Act?
Okay. So Employee Compensation Act is a act which is for the welfare of the employees. Essentially, that was the reason why it was created.
Okay.
It was created in 1923, British time. So at that time, it was known as Workmen Compensation Act. So in order to apply this act, you had to have two things. One, you have to add the definition of workman. So what was workman? That has to be covered. And second, industry. So this act actually and only applied to workmen who were working in industry. So now in 2009 what has happened is the government made an amendment by which the workman, the word workman was replaced by the word employee. So now it essentially covers everybody who's working. Even if there is a shopkeeper who has hired an employee, it will be covered. Even if there is any contractor who has hired a casual laborer, it will be covered. It will not be covered for, let's say, an advocate who has hired a intern or who has hired a associate, because as per the Advocate Act, the person is not employed. So what it covers is essentially employees, any employees. So that's the
Except the advocates.
advocate is a special class, so we should not talk about it. So we will talk about general public. So it will cover all the people who are employees, who are even contractors. So any contractor hiring a casual laborer will also be covered.
Okay, so does this act cover permanent or contractual employees?
So I have answered this question. However, I have said it very clearly. If there is a contractor, let's say he is working on a building, and he had hired some casual labor for that day only. He may have some extra work
For
that
2
day.
hours, 3 hours or something like that.
So this act will cover that employee also for that. However, that employee even may be employed by the principal, that is the person whose building is being made. So who would ultimately be liable for that? That will be the owner. However, again, as I said, even a casual laborer will be covered. So permanent, casual, all forms of employees, laborer, class of is covered in this.
Okay. And how much is the compensation?
Again, the Act defines and gives a table. The premises is this, that a person who is at a certain age, he would live for a certain age. Let's say a person is at 25 years of age. He will go and live for 75, which is the basic assumption today that longevity of life has increased in the country. People will live for a long period of time. So they have a table based on that. If a younger employee dies, then the compensation is much more higher because he will live for a very long time. So his relative or his family need to be considered for that. If a older person, let's say somebody who is of 50 years of age, and he dies, then the compensation will be much lesser. There is a table given based on the age, and there is a multiplication. 50% of the wage is considered in that, and then the multiplication is applied. That is how it is done.
Okay, and where is the jurisdiction? How it is decided?
Again, the Act defines and talks about how the jurisdiction has to be taken care of. So, one is where the employee has died, suppose, or where the employer's business address is. Or the third option it also gives is where the family or the deceased relative or whoever is making that claim ordinarily is residing. So the jurisdiction can be any one of them. It is not something which
So
is
basically, it is dependent on these three factors.
factors, yes. Employee, employer, and the
Place of
person who is
residence.
seeking compensation.
And in which court these proceedings are held?
Again, there are special courts called labor courts, where the commissioner of employee compensation is designated and the jurisdiction lies. So, civil court does not have jurisdiction as far as employee compensation is concerned, because filed under a special court, legal court. Appeal to from these courts are done directly to High Court of the state.
And for an employer, what are the safeguards available in this act?
See, this act has been designed keeping in mind that the employee should be protected. So first of all, we have to understand that the act has been designed in a certain way. Now, what the employer should do? Let us suppose that the employer somehow he has gotten casualty of a worker. So beforehand, companies in this country, insurance companies, they sell insurance called Employee Compensation Act insurance policy or Workman Compensation Act policy. So every employer should, because now it has become very common, and this act applies to everybody who is employing an employee. So they should take a insurance, and the premium is very low. Let's say for 10 people for 1 year, it could be maybe 7,000 or 6,000 or 5,000. So the premiums are very low. However, the safety that it gives, because a compensation would on an average would be, let's say, 15 lakhs or 20 lakhs, depending on the minimum wages in that state. So this gives them the opportunity to safeguard them from such eventuality. So the first thing that a employer should do is he should take Employee Compensation Act insurance policies. That's a very good thing to do. Second, let's say if there is any accident or somebody dies, he should never get into any kind of agreement with the employee. Why? Because any agreement done while when this accident has happened, that is null and void. That means any money you have given to the employee family or anybody will not be counted. And any money or any compensation has to be decided by the Commissioner of Legal Court, and anything that has to be done in front of him only. So nothing is counted. So even if you get into an agreement while an accident has happened, and then you go and say to later on from the Labour Commissioner that we have given him the money, we have taken care of everything, that will not be counted. So let them file the case, and then there you negotiate or you give the compensation whatever that has to be. So this is something the employer has to keep in mind.
Okay, and what should the employer do immediately after any such incident
So
happens?
immediately, as I said, first and foremost thing that he has to do is he should provide the medical care, because there is also a criminal liability that happens. So however he can help the employee, he should do it. Second, he should of course inform the family. Third is that he should not get into any kind of agreement, because that will be
Against
void.
him.
It will be void because it is not applicable. Whatever payment he is making, that will not be counted. And now the law as it stands is the police itself has to report to the labor courts that these all accidents have happened, and who is the victim and everything. And based on that, the Labour Commissioner himself will take up that case. So it is not that the family of the victim has to file a case. So there are two channels. One is the family of the victim will be filing a case, another is the police itself has to report it. So these are some of the things that he has to take care of. And of course he has to contact a good lawyer to take care of things, because what is the legal proceedings. So that would be a good idea.
Okay, and the last question I have is that can you please throw some light on the relation between the motor claims, accidents, and
Yes, so what happens is that the claim can also be filed in motor accident. Let's say the employee is working in let's say transport industry and he dies. So the claim can also be filed in Employee Compensation Act, or if the case is such that it's an accident, then it can also file under motor accident claim tribunal. What is happening is that the trend we are seeing is lawyers are filing these cases under Employee Compensation Act. Why? Because the compensation itself is very high, and they don't have to show the liability. Even without accident, let's say somebody is sitting at home, or let's say somebody is in a truck in the transport industry and he dies of a heart attack. Now, this is not an accident. So maximum liability and the no-fault liability in motor accident claim has been fixed at lower level, whereas employee compensation is much more high. So, can they file two claims? No, nobody can file two claims. But in the victim family, they file it as per what is convenient to them. So we have to see to it that what is being done, and accordingly remedies are designed, and accordingly advice are given.
Okay, thank you so much, sir, for this enlightening session.